And guys, this video is brought to you by 𝗕𝗪𝗀𝗀. Now live on the Binance Smart Chain, you can swap, stake and earn on 𝗕𝗪𝗀𝗀 for extremely lucrative rewards. Now 𝗕𝗪𝗀𝗀 is VenomDAO's latest initiative after establishing ViperSwap, Harmony's leading decentralized exchange. Head over to 𝗕𝗪𝗀.exchange and start earning rewards today. The battle rages on between both Ripple Labs and the US Securities and Exchange Commission. In the most recent court hearing, the two faced off on whether the SEC should produce internal documents on its trading policies. According to one attorney, the SEC is most likely going to lose this battle after the judge fired questions that led the SEC's lawyer to contradict himself. I mean, they definitely don't seem to be trying to win this one. Now, Ripple is fighting to lay its hands on the SEC's internal policies, as through them it could prove that the regulator hadn't established any clarity on to market operators on the state of digital currencies. This builds on the lack of fair notice defense. The SEC, on its part, has been arguing that the documents are protected by DPP. Seemingly at an impasse over the documents, the two fractions held a court hearing on the matter at the Southern District of New York, and this was actually on August the 31st. Now, Judge Sarah Netburn was armed with hard-hitting questions for both sides. One of these was, is the standard for aiding and abetting a violation of law an objective or subjective standard? Now, Matt Solomon, the Ripple lawyer, was quick to refer to a previous case in which the US Supreme Court stated that recklessness in a civil liability sphere is conduct violating an objective standard. Action entailing an unjustifiable high risk of harm that is either known or obvious, or so obvious in fact, that it should have been known. According to attorney Jeremy Hogan, fellow YouTuber, the SEC's legal team had a very difficult time responding to the same question. Eventually, the SEC ended up admitting that this is an objective, not subjective standard. So what does this actually mean, and why does this actually matter? So the SEC stating that this standard is objective is critical to the legal battle at hand. This is because if it were subjective, as in subject to what individual defendants understood at the time, then the SEC's internal policies would be off limits to them. However, being an objective standard requires the SEC to show that what these internal deliberations on the issue were. So Jeremy Hogan did observe the following. If it's an objective test and the SEC is confused, how can the defendants have acted with knowledge of wrongfulness? So Judge Netburn has been giving indications that she believes the internal SEC documents are relevant to the case and should be handed over. After all, she has ruled in the past that the SEC must hand over these documents, although the regulator has appealed this. So again, very vital stuff going on. In an encouraging note to the XRP holders, Judge Netburn did state the following. If the underlying law was so unclear at the time, even to the SEC, then the alleged violations could not have been known, obvious or so obvious to the defendants that they must be aware of it. So this is again really interesting, because how can we expect Ripple or any other XRP holder to know that it is a violation if the SEC did not know either? So these documents, in my opinion, are absolutely vital. So how did the SEC apply the Howey test to determine that XRP is a security? This particular question is one that Ripple and its chairman Chris Larsen have posed to the US Securities and Exchange Commission. In their latest motion, they claim that the SEC has been dodging this question and want the court to compel them to answer it. So this is absolutely vital. So Ripple has been attempting to get the SEC to lay out the process it used to determine that under the Howey test, XRP is a security. The SEC has refused to provide this information, contending that the defendants are seeking irrelevant information, and this is what the company revealed. Now, This is not good enough for Ripple, nor is it good enough for Larsen. The firm is seeking a binding statement from the SEC necessary to narrow the scope of litigation, reduce the element of surprise, and basically serve as admissions for the trial at a later date. In one of the interrogations, Ripple wants the SEC to identify all the terms of contract that it claims created an expectation of profits for XRP purchasers. This is in line with the contention of the Howey test, which claims that for an asset to be deemed a security, a person has to invest money in a common enterprise while being led to expect profits solely from the efforts of the promoter or third party. In past responses, the SEC has pointed to public statements in which it claims Ripple led XRP holders to believe it would undertake activities that would yield profits for them. The SEC is playing cat and mouse, Ripple says. If the XRP is a security under the Howey test, then the SEC bears the burden of proving that XRP purchasers relied on Ripple's efforts to increase the value of XRP. Once again, the SEC has given an evasive response to this as well. Ripple has engaged in efforts that led XRP purchasers to reasonably expect profits based on Ripple's efforts, it stated previously. So the SEC should not be permitted to play cat and mouse on this particular issue, or on any issue really. In an even more contentious argument, Ripple wants the SEC to make a binding statement on whether it claims that XRP holders held some share of Ripple. This is an essential element of the Howey test. The company claims that, and as such, the SEC must commit to a response. On its part, the SEC claims that this is irrelevant to the lawsuit, and I completely disagree. If you are trying to go after Ripple, saying that XRP is a security, then you should be damn right made to prove how you come to that conclusion. If, as defendants, we believe there is no evidence that XRP holders had any expectation of any future rights of payments from Ripple, the SEC must affirmatively state this in a form that can be used at trial. This is what Ripple's motion added. So guys, that is the update from the latest ins and outs of the Ripple versus the SEC lawsuit. As you can tell, there are definitely things heating up nicely, and I do think that ultimately we will end up in settlement. This is basically just due to the fact that the SEC have messed up so many times on this particular case, and if they do have to actually give over these internal documents, I think they will prove that there was definitely not enough fair notice, and the fair notice defense will stand quite strongly for Ripple. If, of course, they are unable to, or Ripple are unable to get their hands on those internal documents, then I do think there will be a slightly longer battle here. But nonetheless, I still feel a settlement is the most likely scenario to save face on both sides of the argument. As long as XRP gets clarity at the end of it, one way or another, I am super confident that the price of XRP will surge shortly after the lawsuit, and we will see some significant gains in the very near term. Guys, if you have found this video useful and informative, then hit the like button. I really do appreciate that. If you are new to the channel, then do subscribe, tap the bell, select all notifications, and in doing so, you will be kept up to date with absolutely everything we do here. With this said, done, and out of the way, I hope everyone has a fantastic day, and I'll catch you all in the next one.